County Bar. It's a pleasure to be in front of you, Your Honors, today. I would like to reserve 3 minutes for rebuttal.
5 or 3?
3, I'm sorry. I kind of blurted out there, Your Honor. Your Honors, this appeal before the court involves the claim of Jessica Forsythe for negligence against the Jackson-Madison County General Hospital District, which is a governmental entity, as well as Pathways of Tennessee, Inc. and West Tennessee Healthcare. On November 23rd of 2016, there was a patient that presented to the emergency room at Jackson General Hospital named Don Fitzgerald White. He came into the emergency room with a butcher knife stuck in his chest. At the hospital, at the ER that night on November 23rd, he was diagnosed as obviously being suicidal, having attempted a suicide. And representatives of Pathways were brought in to assess his mental status. That was completed. Of course, the suicidal diagnosis continued. And there were orders in the chart for him to be escorted by security at all times. That's in volume 4, page 540 of the record. With that assessment,
this is the day before, correct?
Yes.
While he was at the hospital.
That's correct. And with that assessment in place, he was allowed to leave the hospital, but told to return to Pathways, the mental health facility there on the same campus.
When you say he was allowed to leave, you mean he was discharged? What do you mean when you say he was allowed to leave?
Well, yes, he was discharged or released from the emergency room to return as needed if he so desired. At that time, or at all times relevant, the hospital had in place a security policy, policy 909.04, that provided that when a patient was diagnosed as suicidal, that any suicidal patients were to be monitored at all times by security, and the patient's belongings kept at the desk with any staff, medical staff that was evaluating them. There's testimony in the record that Ms. Forsythe and other employees of the Pathways were prohibited from searching and taking personal items from the patients. It's undisputed that while Mr. White was in the triage area, which
day are we talking about now?
Okay, I'm sorry. On November 23rd, he was at the ER and released and allowed to leave the ER. The next day, with that policy in place, on November 24th, which was Thanksgiving Day, Mr. White presented to the triage area. There were...
This is at Pathways?
That's correct,
okay.
At Pathways. There were no security officers on duty at the Pathways facility. He was not monitored by any security officers of the defendants. His belongings were not secured by any security officer. With that diagnosis, and while he was in triage, he had a knife in his possession, which he used to stab Ms. Forsythe, my client, over 100 times, leaving her horribly injured and disabled.
I mean, but is there any question here that Mr. White was being provided medical services?
No, there's no question. He was being provided.
He was there.
He was the patient.
Yeah, he was there to be provided medical services.
That's correct. He presented to Pathways triage.
So why doesn't that put this under the Healthcare Liability Act?
Well, Your Honor, because this is the complaint and the claim of the plaintiff is based on failure to execute a policy that they had put in place themselves. Okay, not every set out in my brief. Not every case filed against a hospital or a medical provider is a medical malpractice case. Here we have a policy, a security policy. We have security staff at the hospital.
How do we know that that's just a security policy? To me, this policy also has healthcare overtones, because you certainly, I mean, you wouldn't necessarily assume that it was for the safety of others. It might have been for the safety of the patient.
Well, I think we have to go to, what is a healthcare liability claim, and then come
Our
backwards from
legislature
there.
has made it extremely broad. I mean,
I understand that, Your Honor, but again,
and that is clearly in response to some decisions of this court even, where we've tried to figure out, does it actually fall under? And I think with the most recent, well, I can't really call them most recent amendments now, but in the near past, the legislature has even broadened it further so that they have done away with Tennessee Supreme Court cases like Elthorpe and others. I mean, it's so broad these days. I mean, I don't know what fits outside of it anymore.
well, for instance, hitting a patient or striking a patient is not an allegation of healthcare liability. Rape and if a doctor or a security officer rapes or assaults a patient, that just because the hospital is a named defendant in it, the hospital,
Right.
the patient is there to receive
Those
health care.
circumstances, the security guard is not being provided healthcare services. Here, the assailant was being provided healthcare services.
He was provided health care services, but again, Your Honor, this is a claim, I'll call it a premises liability claim, a lack of security claim. The hospital
Right, and
had a
I-
policy and they failed to enforce it.
And I understand that and I'm sorry to interrupt, counsel, but I just want to make sure we stay on the right track here. I understand that is how it survived a motion to dismiss here. It's really premises liability here. But then premises liability, we'd be looking at other things. Wouldn't we be looking at, was there another incident of this occurring so that they would be on notice for purposes of, had Mr. White been on the property before wielding a knife, or had there been another knife-wielding person on the premises to make them, or put the facility on notice that might be a potential or foreseeable possibility of a danger to people on the site. But that's not what we're having here. We're having, how we should have treated this particular patient, Mr. White.
Well, and with all due respect, Your Honor, not to be argumentative back
No,
to you, I guess that's what
this is the
argument
time to
is.
be argument,
This is the time
Counsel,
we
yes.
can be argumentative. Your Honor, the allegations in the complaint, we didn't get that far in this case. There are allegations in the complaint that, quite honestly, I know it's not that complaint's in the record, but there are allegations in the complaint that this was a, dangerous area, multiple complaints of, patients coming to the ER mentally disturbed, patients coming to Pathways mentally disturbed, that would put the hospital on notice. So we weren't allowed to get into presenting all the elements of a premises liability claim, because what happened is motion for summary judgment was filed. We had a motion to motion for summary judgment based on, three points. That this was a healthcare liability act, that this was not foreseeable, that the accident was not foreseeable, and therefore the hospital owed no duty to Ms. Forsythe. And, I'm sorry. GTLA, thank you, Your Honor. The discretionary function immunity. And so in his rulings, Judge Morgan ruled against the defense, ruled against the hospital, saying that this, we made a prima facie case that it was foreseeable, and that we were traveling on a policy that was that got us around the discretionary immunity thing. In other words, there's a policy that was there, they just didn't enforce it, and that's what we're traveling on. What he dismissed us on was saying that that this was a healthcare liability action. So again, I think we have to come back to, whether, every case that is filed against a medical provider is a medical malpractice case or a healthcare liability case. There's basically, the cases that I cited in my brief, there's basically the analytical path that, remains or is established from those cases that for it to be a Healthcare Liability Act case, it must be related to the actual provision of health care. Our liability is based upon failure our theory of liability is based upon failure to execute their own security policy. The second, way that we deem something a healthcare liability action is it must be related to the job duties that makes that person a healthcare provider. In other words, there's cases in there that say it is a healthcare liability where someone falls off of a stool in an x-ray room because it's part of the medical provider's job to provide a stool for its patients, okay?
Why is this not similar to that? Why is this, I suppose, a different situation? Because as I understand it, and honestly I was confused on the front end when I was reviewing this, because I was trying to ascertain whose medical advice or whose medical analysis we were actually looking at. Are we looking at the medical decisions made in the emergency room, or are we looking at the medical decisions on the following day? And I'm assuming we're only looking at the medical decisions on the second day. Is that correct?
I would answer that, Your Honor, by saying we're not looking at the medical decisions, period.
Well, let me pose this to you then.
Okay.
There was a policy in place,
Correct.
and this policy required someone to make some decision about somebody suffering from some mental illness, correct? They
No.
throw intoxication in there as well.
No, Your Honor, the decision, this is a diagnosed suicidal patient. The policy says security.
Who was released.
Okay, right.
Discharged.
And that suicidal patient came back to the hospital.
And your client,
My client pulled up the record and it said right there, here's a suicidal patient.
who
Okay?
is trained to do this analysis, correct?
That's correct, but she is not a security guard. She is not responsible for implementing a security
I
policy.
think that's where perhaps we're having the disconnect. You're okay.
Okay, thank you, Your Honor.
While you're answering the question, you're okay. The disconnect is this. Whose decision was it that security was needed at that point in time?
The security department did not have anybody there. They did not monitor.
Let's set that aside. Did your client feel the need for security?
Okay.
Based upon what, everything she knew? Was there anything that she didn't know other than the assailant had a knife in his pocket?
Okay. Would you re-ask?
Was there any material information that your client was not aware of, except for the fact that this guy had a weapon on him?
I would have to answer no.
Okay.
But
And she was prepared, or she was trained, was she not, to make these decisions?
she is not trained. Well, I'll answer that by saying there is testimony in the records supported by affidavit of at least one witness and her own testimony that they were prohibited from searching patients and asking them if they had a knife.
I understand that, but that's not answering my question. Was she trained to recognize this person could be a potential threat because of suicidal ideations or mental disabilities or whatever?
She was trained as a psych tech, and part of her training would have covered signs of agitation.
Which would have led theoretically to call for security.
It could have, okay?
Could have, should have.
Your Honor, I can only respond to that by saying she is not trained in provision of security. She was.
I thought she was trained, had all this combat training as a paramedic or something.
She was an EMT in the military,
Okay.
and yes, she had training to how to sew up and bandage up bloody soldiers dying in the field. Okay, but that's not the same as
Okay.
security training,
Okay.
and so and she's not. That's not within her job duties.
All right,
So there's no medical
my
judgment there.
question, and
Let me
oh,
ask you
excuse
one
me.
thing.
Sure,
Let
Judge
me ask
Armstrong
you,
has
in
it.
your complaint, did you put at issue whether or not it was appropriate to release the assailant from the hospital after the visit to the emergency room? Was that an allegation of negligence in your complaint?
That was an an allegation of negligence in the complaint. Those defendants, the physicians and the corporation providing medical care and using medical judgment to release him the night before, those parties were dismissed
So that was
without a fight. So again, we're proceeding on a premises liability or a failure to follow proper security policy that they put in place themselves.
Okay, all right.
You got your rebuttal.
Thank you.
Thank you. Sure you'll provide clarity to this, Mr. Reading.
Sorry, I didn't catch that.
I'm sure you'll provide clarity to all this.
Absolutely. That's what I'm here for. Good morning, Your Honors. Brandon Reedy here on behalf of the Appellees, which we will collectively refer to as Pathways. The Healthcare Liability Act, since 2011 and following the decision in Ellithorpe and the Supreme Court's decision earlier this year in Cooper versus Mandy, very straightforward, defines healthcare liability action as any civil action alleging that a healthcare provider or providers have caused an injury related to the provision of or failure to provide healthcare services. And the key phrase following that is regardless of the theory of liability on which the action is based. The reason that's significant here is because prior to this enactment, it was typically known as medical malpractice or just medical negligence arose in this context. Now, based on the language of the statute and the court's decisions, it is now encompassing all claims, including those outside of medical negligence. Here, it's a narrow question. It's undisputed that my clients, or the appellees, are healthcare providers. Undisputed that this is a civil action. Therefore, the only issue is this a healthcare liability action? We contend that it is a healthcare liability action. And what even further narrows this question is the way it's phrased and presented by Ms. Forsythe is it's in the context of a security or safety policy. So the question becomes even more narrow of is this claim based on the safety and security policy a healthcare liability action? We contend that it is because, as Your Honors noted, and the intro language to that policy specifically requires healthcare decision-making and judgment. Policy and procedure states that when a patient presents to crisis triage and is considered high risk due to suicidal or homicidal ideations, gives other examples of things at which they may present, the following precautions will be implemented. As Mr. Smith stated, this individual will be monitored at all times, or belongings will be kept at the desk with staff. Again, that's not self-executing. That requires first an assessment and determination that the individual is suicidal. What's significant here, and I think it's very apparent from appellant's brief, is there's 6 references total to the word suicidal in reference to Mr. White being suicidal. In all 6 instances, there's no reference to the record whatsoever. And the reason is because there's not a diagnosis of suicide on the date that this incident occurred.
There is no record of, or there is no diagnosis of him being suicidal?
That's correct. On the date of this incident, he did present the day prior to the emergency department with a self-inflicted knife wound. Trying to kind of go through my head of what's all in the record, but to the extent his medical records, there are portions of them in the record. I believe it's in the Statement of Undisputed Material Facts and the responses there too, set forth that when he was discharged, he was determined to be stable, no longer having any kind of thoughts of self-harm, and they felt at that time it was safe for him to be discharged, and if he had any additional issues or felt like he needed further treatment to go to Pathways. While I can't directly speak for them, I can almost be certain that a healthcare provider wouldn't just discharge someone into the public at large who's claiming to be suicidal.
So let's make sure about I want to make sure I understand what you just said. Was it discretionary with him as to whether he went to Pathways, or was he directed to go to Pathways?
It's similar to what you'd see in any medical record. If you were to go to the doctor and they say, if you have any further problems or your condition worsens, return to your primary care provider. It was essentially, if you have any further issues, if you feel like you need additional treatment, we suggest that you go directly to Pathways for these issues specifically you're presenting with now, as opposed to returning back to the emergency department. Let's go straight to Pathways that specializes in this type of treatment.
And does the record reveal whether he himself, he voluntarily went, or someone took him to Pathways that day?
His father took him to Pathways that day.
Okay, but was it because that's what he wanted to do, or is that what his father wanted to do? Do we know, or does the record say that?
I believe the record, and based on the testimony of Ms. Forsythe, it's in her deposition testimony that we set forth in our brief. I can grab that site real quick. It's in volume 8 of the record. When asked specifically if she thought that she was at risk or that this individual gave her any concern at all, she said no. She said to the effect of talking about her radar and that she is very skilled in this area, and that many complimented her on her abilities in assessing patients. And she specifically mentions, sorry, I'll find this for you real quick. This is on page 11 of our brief. It's her deposition in volume 8. Although she did make statements that she did not believe he should be discharged, she explained that he didn't give me any indication to worry, anything more than normal. I knew what he did the day before. His behavior at that time wasn't showing anything erratic. And she goes on to explain how she made that determination. So from the record and what we do have before us, he did appear voluntarily with his father.
So I'm just curious, who carries out this policy when someone is presented with suicidal ideations? Who carries out the policy? Who would be responsible for searching the patient for weapons?
Right. So the first step with this policy that requires a determination that the individual is suicidal, homicidal, showing elopement risk, psychosis, that's first determined by a staff member at Pathways. Here, that individual happens to be the plaintiff in this lawsuit, Jessica Forsythe. This makes this case a little bit more unique and a bit confusing in the sense that you don't normally see employee-employer type actions due to workers' compensation.
She was an independent contractor.
She is an employee, but so Jackson, Madison County General Hospital District and the Pathways defendants are governmental entities, municipal corporations exempt from those requirements of workers' compensation. They do have self-imposed on-the-job injury program in place, but that's kind of why this case is a little more unique. The only similar type case I could really find with similar type allegations is Turner versus Jordan, 1997 Tennessee Supreme Court opinion, where a psychiatric nurse was attacked by a patient, filed suit against the doctor, the psychiatrist, and medical negligence claim at that time was a medical negligence claim. The opinion doesn't discuss really much about the context of any type of medical negligence statutes or anything, because obviously it was in 1997. The law at that time was different. But they determined in that case that the psychiatrist may owe a duty under those circumstances to reasonably identifiable third persons with respect to a potentially dangerous patient.
That was a medical negligence case.
That was a medical negligence case, yes.
Let me go back to where Judge McBrary just left off, or maybe not. I don't know. This is kind of... The policy says when a patient presents to crisis triage and is considered high risk due to suicidal or homicidal ideations, psychosis, elopement potential, and/or intoxication, the following precautions will be implemented. Did the plaintiff determine that any of those high-risk options or high-risk alternatives were present?
No, she did not.
Okay, so does that end our analysis of this policy?
I believe so.
Okay. And is there any, from your perspective, I know I asked Mr. Smith this a moment ago generally, but is there any question that the plaintiff has received the proper training to make that determination about these ideations?
From the record and from, I believe, everyone's perspective, everyone would say it's undisputed that she was properly trained and able and, to make this determination, and that she, even in her deposition, talks at length about her experience and abilities in this area. And I think she even talks about how her coworkers, touted her abilities. She refers to it as her radar, is what she calls it. But there's no issue with whether or not she is trained in this area to make that determination.
Is there specific training required by her employer for this particular position?
Yes.
Is that in the record?
It should be attached to, as an exhibit to her deposition. I don't have her actual deposition before me, but I know that there's extensive training required, and they do go through that training. We did go through that with her in her deposition, and that's why the discussion comes out of her abilities and her experience in that area, and as you mentioned earlier, the prior medical combat training, things like that.
Okay.
I cannot state definitively that the policies or training policies or orientation type materials are attached to her deposition. I believe at least a handful of those are attached, but I'm not certain if all are present there.
What's the name of this policy document? Is it actually called Safety and Security Policy? Is that the name of it?
The one at issue that they're saying, so this is a pathways policy, and it's a safety and procedure policy that's applicable to specifically pathways crisis triage, where this incident occurred. And I believe why this is relevant in kind of the grand scheme of things, while we contend that policy does not apply for the simple reason of when he presented, he was not suicidal. An assessment was not determined or made determining him to be suicidal. Therefore, the additional steps that would follow that
did not kick in.
Right.
Yeah, in the policy itself, though, it's designed to protect the safety and security of clients and staff,
Correct.
right?
Correct.
So it doesn't say anything about visitors.
Visitors. Well, so clients would be patients or
Right,
individuals
yeah.
presenting for
So,
treatment. Right.
I mean, so I guess visitors are on their own at Pathways.
Well, typically, they have the ability to do like entrance control. It's not a place that's frequented by, just common people walking along the sidewalk. They do have the ability to,
Although Mr. White's father was there, I assume.
presented with Mr. White
Yeah.
at Pathways Crisis Triage.
But by the terms of the policy, he's really not covered. It's not to protect his, he's a visitor. He's not a client or staff.
I'm not sure if the term client is defined in actual policy documents, but I do know that the hospital, just on a larger scale for this hospital campus, which Pathways is located on, does have policies, procedures that relate to just individuals of the public that are there present on the campus.
Is Pathways just an outpatient facility?
It has outpatient and inpatient care.
Okay.
And that's when this incident occurred. Mr. White and his father were in the waiting room awaiting to be admitted into the stabilization unit of Pathways.
Okay.
Is that the inpatient area?
Yes.
Okay.
And so Ms. Forsythe had done her assessment at that time. He was asking to be admitted. She had no concerns as he presented at that time. So she was in the process of kind of waiting. Another counselor arrived. They were in the process of basically waiting for him to be admitted when this all occurred. I think one thing that's telling here, as far as background, typically the cases that we've seen and that this court has addressed have dealt with a Rule 12.026 motion of the allegations of the actual complaint. Here, we did file a motion along those lines. It was denied, but it was probably the best we felt after losing a motion, just because the way the court crafted it, it basically said these are definitely allegations of healthcare liability. Therefore, hence we're the only defendants left. The rest all got out on those grounds. But the court definitely said that if, to the extent you're going to be proceeding on this premises liability theory that you've raised, it's got to be premises liability. It can't be all these, allegations of negligent discharge and so on. Here, as I believe the record is clear, since it's a summary judgment, they had the opportunity to present a healthcare liability action or a premises liability action. We teed up the summary judgment motion saying that this specifically was healthcare liability, despite the fact that numerous depositions, expert proof was taken. And at the summary judgment stage, we showed that although they said premises liability, what it comes down to is policy that while they claim a diagnosis of suicide existed, that diagnosis had to be made by someone on that date who was the plaintiff. And just an overarching theme here is that healthcare services at all relevant times were being provided to Mr. White. So on the day prior, when he's in the ED, when he's discharged, when he comes back to Pathways, including the time at which the incident occurred, healthcare services were being provided to him. He was in the admission process of being put in the crisis stabilization unit. So that checks off the healthcare services provided to a person, and then you're left with the definition of healthcare liability action, which we contend is broad enough to include any theory of liability on which the action is based, including premises liability. The statute specifically states, 2926-101C, that any action that's subject to this part is subject to this part regardless of any other claims or causes of action or theories of liability alleged in the complaint. I believe one of the last points I want to make sure to hit on is the Newman case. I believe the Supreme Court's most recent pronouncement in Cooper versus Mandy says, since Ellithorpe saying that the estate of French nuance approach is out, where we are now is we haven't changed our approach to this. Our interpretation is the same. The statute is very broad. And the first case they cite for that proposition is Newman versus State, which is the case that we rely upon heavily in the sense that in the context of a mental health facility, determinations made regarding care, treatment, supervision of these types of patients in this context and with this patient population requires expert medical proof, which ties into the pre-suit filing requirements of the statute. And as far as the other opinions that were discussed, including Ms. Lacey, who kind of a frequent flyer of the Court of Appeals, I wanted to point out that in Cooper versus Mandy, the court specifically did not follow the decision of Lacey versus Mitchell for the proposition of the temporal analysis as far as when the injury occurred. The court did not take that argument and said it did not apply to that situation to determine that medical battery and misrepresentation were healthcare liability actions. Thank you.
Thank you. Mr. Smith, I believe you have 3 minutes.
Thank you, Your Honor. I'm going to try to hit some points, and they're not necessarily probably in the proper order. But I think that while the record is replete with my client, Ms. Forsythe, receiving training as a psych tech, she is not trained to determine or diagnose psychoses and suicidal tendencies.
Does the record contain what the hospital required, what her required training was? Does the record contain what her required training was to fill the position?
There are exhibits to her deposition that just say she attended this course, this course, this course, this course, this course.
Okay.
And so, but I'm just prophylactically stating that those do not, that she did not receive her training on diagnosing. She's a EMT basically, and not a doctor. Again, he was talking about the Newman case. I'd like to contrast the Newman and the Forsythe case. In the Newman, which is what Judge Morgan relied on in granting their motion for summary judgment, saying this is a Healthcare Liability Act. In Newman, both part of the assailant and the plaintiff that sued the medical provider were both patients. Here we have an employee that is suing her employer. In Newman, the plaintiff was suing a state medical facility for failing to assess and monitor a psychiatric patient. Here we have a plaintiff suing her employer for failing to execute a stated security policy. In Newman, there's no security policy. In Forsythe, we have a security policy. In Newman, Beasley attacked a patient, and one of the patients was killed. Here, we have a patient that attacked an employee, and there was no security in place. There was at that facility, there's expert witness testimony that was taken that, you know, supports that this policy was not executed. Again, you know, he was talking about the Lacey versus Mitchell cases. The Lacey cases that are cited in our brief as authority also stand as authority that one complaint can allege both healthcare liability and negligence, and the Court of Appeals in that particular case let battery and assault charges stand while dismissing medical negligence. Finally, just as an aside, I'd like to say that, you know, I would just ask the court to consider, you know, if this is a healthcare liability claim, and what procedure will we have to follow? You know, you give notice to providers. You know, who are we giving notice to? Ourselves? You know, you're supposed to provide a release so that everybody can obtain the claimant's medical records. Well, what would Jessica Forsythe's medical records tell us about whether there was or was not proper security at the hospital, or whether a policy was implemented? So, again, we don't have to prove that in this case because it's not a healthcare liability case. So there's no point, there would be no point in requiring her, if this were a healthcare liability case, there'd be no point in her providing her medical records to the other side, because it says that just is going to confirm that she was stabbed over 105 times and was left permanently neurologically damaged and can never work again.
Thank you. Thank you. Thank you, gentlemen. We appreciate your argument. We will take this matter under advisement and attempt to render an opinion at the earliest possible time. We'll stand in recess until the call of the docket this afternoon.
All rise.